Liberty Nation with Tim Donner.
And now it is time to welcome in our regular contributor, constitutional lawyer and LibertyNation.com legal affairs director Scott Cosenza for the portion of the program which we entitled Talkin Liberty. Hello, Scott.
Tim, from the very cradle of liberty is where I join you today.
You're talking about San Francisco or?
No, Tim. That's the Rice-A-Roni town. I'm in Philadelphia, Pennsylvania, sir.
Oh, that cradle of liberty. Okay.
Yes, sir.
Now that we clarified things and why you would voluntarily go to Philadelphia, I don't know. Did you win the second prize in that contest? You know, the first prize is 1 week in Philadelphia.
You're lucky you're not. You talk to me like that at a distance only, okay? I'll have you know that, all right?
Fighting words for the man from Philadelphia and guardian of individual liberty. So, Scott, let's jump right into this ruling by a federal judge, a district judge, and that's important to point it out because there'll be other layers of appeal available to the White House. But a district judge has ruled in the case of Don McGahn, counselor to the president, that there is no absolute immunity from testifying before Congress for members of the president's White House staff. This is a potentially significant ruling if it survives all the way up the chain.
Tim, this is the House Judiciary Committee suit against Don McGahn, the president's official lawyer. We often hear talk of Rudy Giuliani and others as his personal lawyer. This is from the White House counsel's office, paid for by the taxpayer dollars to represent the office of the presidency. And they want his testimony on some impeachment inquiry matters, send him a subpoena to secure that testimony. And he said, or the White House said, they have absolute immunity and do not need to send their people down there to testify. Judge Ketanji Brown Jackson says the Democrats, the Judiciary Committee is right, that the president does not have absolute immunity for these people to not have to go before the Congress. Now, there's been some misreporting I've seen, I think, Tim, that leads people to believe that the judge in this case has said something about, that he'll lose the attorney-client privilege or something like that. No, Mr. McGahn may go down there and present himself to testify and then say nothing at all and assert those privileges in person. But he cannot simply not show up. That's what this ruling says.
So obviously the White House has done this because they're sick of being subpoenaed and turning over millions of documents like they did for this whole Russia collusion thing. And so they're saying, no, we're not going to go for another one of these fishing expeditions. They also say, and I think legitimately so, that privileged communications between members of the president's staff, if those are revealed, it puts a real damper on the kind of advice and consent that the president can get in the privacy of his office. So how legitimate are either or both of those arguments?
Well, I think the second argument does not carry any water because this argument does not touch privileged communications. All it says is that you have to go to the hearing room and assert the privilege. You can't just phone it in and say, oh, these are privileged. I'm not going to talk to you, which is the appropriate form, I think. I always laugh, Tim, when I hear about the news of these congressional things from time to time. I hear about a filibuster, but it wasn't a filibuster. They just said that they were going to filibuster, so they never actually put the legislation forth. And you think, oh, gee, how lazy. Well, this is sort of the same thing. You can't assert a privilege without actually asserting it. And this absolute immunity thing, this actually is an invention of the sort of Harriet Miers Justice Department. And carried over, in a sense. That's when it was first asserted. At least that's according to Judge Ketanji Brown Jackson, who wrote about it in her opinion supporting the ruling. And she finds there's just no grant in history or our Constitution or law for such an absolute immunity grant. And I have to say, as I read the opinion, I did find it rather compelling on that point.
Okay, well, let's move to where you are, Pennsylvania, where the Supreme Court has ruled the Fifth Amendment to the U.S. Constitution bars people from being forced to turn over their personal passwords to police.
Tim, as I talk to you now, I'm looking at the first home of the Pennsylvania Supreme Court, which predates our United States Supreme Court. It's a building known to many as Independence Hall. And the justices did a great thing for liberty and independence here in a very tough case. And I say it's a tough case because it involves child pornography, and we know that often uncomfortable facts make for bad rulings in law because oftentimes, well, you can imagine the pressures involved. So, Tim, what we have here is a person whose computer's been seized by law enforcement. They believe that they will find child pornography on that computer if they got access to it. The defendant has refused to input the password, and they say that he's legally compelled to do so. The police and just the prosecuting authorities say that the defendant has to put in the password. Well, it's sort of like keys or keys to a locked filing cabinet or a combination to a safe is how the prosecution's office wants the court to process these requests. And in those instances, you have to produce those. So you don't have a Fifth Amendment right, Tim, to keep your safe. If you have a safe in your office with some books in it and the IRS or some other agency wants to look at those books and they have a reason in law to do so, you can't not give up that that combination of the safe or those keys to the filing cabinet. But the Pennsylvania Supreme Court, Tim, here has created a major decision where they've said that these passwords are not the same thing as a keys to the safe, as it were, and that we have a privacy interest in them, and that the court that individuals cannot be compelled to turn it over. And I think it's a great ruling for liberty. This combined, Tim, with the case we reported on, I think it was 2 weeks ago, where we now see that at border crossings, rather, they don't have the right to inspect your electronic devices absent some reasonable suspicion, at least, or probable cause. I think that, the last couple of weeks has seen a great deal of movement in a positive direction for individual liberty in the electronic sphere and digital privacy.
Well, no question there must have been tremendous pressure to give in on this case based on the fact that it was, the worst kind of crime in people's minds, child pornography. So this is where the rubber meets the road when it comes to making legal rulings. You have to base it on the principle and the law and the Constitution, and not on how you want the case to turn out. It can't be outcome-based judging, is what you're saying. And we've talked about that frequently. Okay, let's move out to the West Coast now. In Oregon, where cops are no longer allowed to routinely turn traffic stops into criminal investigations, which I think it's shocking to know that they'd been allowed to do that up to now.
Well, that, Tim, is very popular, and it's really instituted with the drug war. That's when police started to become entrepreneurial about these things. That you combine that, Tim, with the fact that so many towns and cities and states rely on these ticketing apparatuses for a great deal of their funding. And you see you've got a positive feedback loop or a negative feedback loop for liberty's perspective. And I think it's a great, unfortunately, by the way, what happens with most of these stops is they really, the ignorant suffer more than any. For the sophisticated person who has a sense of what the law is and what the powers of police are, they feel much more confident telling the police to go mind their business and let them be on their way. But the fewer years of formal education a person has, and you can imagine, this plays right into the sort of, it's poor black and brown people. They get it the worst, not to mention the underclass generally. So they're also the ones that are more likely to have interaction previously with the criminal justice system and kind of increase that loop. So I think it's a great thing. Nothing in this ruling which says that investigative activities conducted during a traffic stop need to have limits. If a cop gets a hinky vibe, Tim, if he thinks there's criminal activity afoot, he's encouraged and should go ahead and investigate that. That's not what this is about. This is about, as a matter of course, treating every interaction like, okay, let's try to generate an arrest here from just because we can. And as you've pointed out so many times before, you can't operate a car without violating the law for more than a mile or so. There are so many. So
you've been going 2 miles an hour over the speed limit, sir. And by the way, while I've got you, you've been beating your kids lately? How about your wife? Have you been saying libelous things about your boss at work? That's the kind of thing.
How about Tim? How about you drove your mom to the doctor's office and she left her prescription bottle in the side pocket of the door and didn't tell you about it and didn't leave you a notarized prescription to be able to possess opioids, and the cop searches the car and finds him because you gave him permission because you're not a wrongdoer and you thought you were doing the right thing by letting them search, and now you're in prison. That's the kind of thing that gets people hemmed up, for real.
Now, one more story. There's only 2 states in the country that prohibit the ownership of stun guns and tasers. Those are Rhode Island and Hawaii. And now Rhode Island's ban on stun guns has been challenged in federal court.
Our heroes, Tim, are Michael O'Neill and Nicolo Grasso, who filed the claim. And I think it's important to talk about because the struggle is not just for deadly force in terms of the right to keep and bear arms. While there's no right to a stun gun in the Constitution like there is to keep and bear arms, this is one of those things where they won't even let these people have less than lethal protection. And I just think it's shocking that that's where we are with so many people who want to remove from adults the ability to be able to protect themselves. It won't stop at guns.
All right. Well, thank you, Scott, and enjoy your time, however difficult that might be in Philadelphia. Enjoy the fullness of your Thanksgiving holiday.
Happy Thanksgiving to you and everyone listening, Tim.
This program, Liberty Nation Radio and LibertyNation.com's own podcasts, The Uprising, hosted by Scott, no matter where he is, and The Rabbit Hole, Politics and Prose with Mark Angelides, where past is prologue, all available on demand at LibertyNation.com. So we wish all of you a joyous Thanksgiving weekend and hope to see you back here next week. In the meantime, this is Tim Donner saying stand up for liberty. Have a great weekend.